PTI's candidates as independent candidates was illegal, unconstitutional, and inconsistent with not only Section 215 of the Elections Act, but also inconsistent with Article 17 of the Constitution. Nawaz Sharif's decision in 1993, rendered by the Supreme Court has held that the rights espoused under Article 17 of the Constitution do not just include those rights which are expressly spelled out, but it also includes certain peripheral rights. While the Supreme Court's decision in the reserve seats cases characterizes one of the most important moments of our constitutional and jurisprudential history. Before delving into the decision itself, let us bear in mind that this decision comes at a moment where the government is considering bringing a constitutional amendment which not only encroaches on the independence of the judiciary, but which also affects and chips away the powers of the incoming Chief Justice, who is also the author of this decision. Perhaps given our social and political realities, it would also be important to acknowledge the immense courage that the majority displayed in authoring and rendering this decision. Now, delving into this decision, the court has once again underscored the importance of Article 17 of the Constitution, which deals with the political rights of individuals. And the court has held that the rights enunciated under Article 17 of the Constitution include the right to contest elections through a political party of one's choosing. Now, we have seen since the Benazir Bhutto's case in the 1980s that the Supreme Court has held that the political rights espoused under Article 17 do not just include the political rights of individuals, but also include the political rights of political parties. Now, similarly, since the Nawaz Sharif's decision in 1993, rendered by the Supreme Court has held that the rights espoused under Article 17 of the Constitution do not just include those rights which are expressly spelled out, but it also includes certain peripheral rights, or certain rights in penumbra which lurk under the surface of the Constitution's express text. So as such, with the Supreme Court holding that Article 17 provides the right of political expression to all individuals and to political parties, the court then examines the Election Commission's decision. Now, Section 215 of the Elections Act provides that a political party which does not conduct intra-party polls, or which does not provide details with respect to its own funding, may fall foul of Section 215. And as a result, the Election Commission may have the right to strip that political party of its electoral symbol. So as a result, we saw the Election Commission denying the PTI of its electoral symbol, and we saw that that decision was also upheld by the Supreme Court. Nonetheless, the Supreme Court in this decision held that the consequences of Section 215 had to be examined strictly, because any statute which impinges on the rights of individuals or which results in penal consequences ought to be construed strictly. So the consequences of Section 215 could have only been such which were expressly laid down in the law. And as a result, the consequence of PTI not conducting intra-party polls could have merely been the denial of its electoral symbol. The importance of this aspect of the decision is that the court holds that, notwithstanding its own earlier decision, where it upheld the denial of PTI's electoral symbol, the court holds that such denial could not have denied the PTI's existence as a political party. The court holds that, notwithstanding that decision, the PTI's existence was not affected, and as a result, the PTI still had the right to nominate individuals for elections to the parliament. And as such, the Election Commission's decision, through which the Election Commission denied PTI the right to nominate individuals for elections, and the Election Commission's decision to declare the PTI's candidates as independent candidates was illegal, unconstitutional, and inconsistent with not only Section 215 of the Elections Act, but also inconsistent with Article 17 of the Constitution. Now, having held this, the Supreme Court then dived into the language of Article 51 of the Constitution. It held that Article 51 espoused a principle of proportional representation, and as a result, any political party deserves and ought to receive seats for women and minorities based on the number of seats that political party had secured. Now, interestingly, the 8 judges in the majority and 3 other judges, including the Chief Justice, were in agreement until this point. They agree that the Supreme Court's decision upholding the Election Commission's denial of the PTI's party symbol did not affect the legal existence of the PTI. They also agree that the Election Commission misconstrued the Supreme Court's earlier decision and that the Election Commission ought to have allowed the PTI the right to contest elections. They also agree that Article 51 of the Constitution deals with proportional representation. The only disagreement then is what relief should the Supreme Court have given to the PTI. And while 3 judges in minority, including the Chief Justice, were of the view that any individual who had joined another political party or who had submitted a declaration to this effect could not be treated as a member of the PTI, the majority departs from this understanding. And interestingly, the majority says that we cannot remain silent spectators or we cannot remain unaware of the realities which underpin this. They hold that those individuals who had decided to join another political party or who had submitted declarations to this effect did not do that on their own volition. Now, this is extremely important. And with the Supreme Court subsequently also holding that electoral disputes cannot be treated as any other ordinary civil dispute, or that the Supreme Court's scope in electoral disputes is more inquisitorial in nature, this aspect is perhaps extremely important because it also affects the credibility of the entire electoral exercise. With the Supreme Court holding that PTI's members who were compelled to join another political party did so under pressure, it raises a number of concerns about the validity and about the credibility of the entire electoral exercise. Now, one other aspect of the decision which is also interesting is that 2 of the judges, Justice Aminuddin Khan and Justice Naeem Afghan, had held that given that the majority's opinion was inconsistent with the Constitution, as a result, the Election Commission did not have to follow the majority's decision. Now, unsurprisingly, that aspect or that opinion rendered by 2 judges was extremely dangerous, given that it allowed a subsequent minority to simply disregard the opinions or the judgments rendered by the Supreme Court's majority. Interestingly, the majority opinion has also observed that this remark by 2 of the Supreme Court's judges was unbecoming of judges of the Supreme Court. Now, this is extremely interesting and perhaps also extremely disconcerting because the tensions which have characterized the court in the past is now making way through judgment of the Supreme Court. Now, initially we would see letters being exchanged by judges of the Supreme Court, but nonetheless the language which has been used by the majority also underscores and also highlights the tensions simmering under the Supreme Court. But nonetheless, that remark or that observation was perhaps also extremely important given the dangers and the perils concomitant with the remark made by the 2 judges. And we have seen that notwithstanding the majority's decision, the majority's judgment, the Election Commission has repeatedly endeavored to not follow the Supreme Court's judgment. The Election Commission has attempted to find ways to skirt around the Supreme Court's decision and circumvent the Supreme Court's judgment. So as a result, this remark by the majority was also extremely important, and it also once again underscored the importance of complying with the Supreme Court's decision.